Good day, ma'am. I am Jeneriel Cagas from BSHM 3B, and for today's video, I will be report a chapter 4 entitled Law on Partnerships and Corporation. So, we have learning objectives. First is differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporators. Then, identify the requirements in the formation and dissolution of partnerships and corporations. The law on partnership is governed by the Civil Code of the Philippines, while the law on corporation is governed by Batas Pambansa BLG 68 Corporation Code of the Philippines. The law, Article 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Partnership means is an association of two or more persons to carry on as co-owners of a business for profit. A partnership contract is based on trust and confidence. Then, delectus personnel. No one can become a partner in partnership without the consent of all the partners. Then, the essential requisites of a partnership are 1. An agreement to contribute money, property, industry to a common fund. This is complied with if one of the partners bring of is A. Each one of the obliged to bring something to partnership, the B. That what which is brought becomes common property. Second, intend to divide the profits among themselves. This is complied with following A. Partnership is established to obtain profits. B. Profit must be common on the parties, and C. Profit or loss must be divided among the partners. So we have advantages of forming a partnership. These are: first, easy to form; second, improve growth possibilities; third, freedom from bureaucracy. Then we have disadvantages of forming a partnership. First, instability. Second, difficulty in obtaining large sums of capital. Third, firm is tied to the acts and judgment of one partner as agent. And lastly, difficulty in severing partnership ties. Then we have classifications of partnerships. One is according to subject matter, and we have universal partnership and particular partnership. Second, according to liability, and we have general partnership and limited partnership. Third, according to duration, we have partnership for a mixed term, means is one in which the term of its existence has been agreed upon expressly or impliedly. Next is forms of partnership. First, when it is stipulated. Second, when immovable property or real rights are contributed. Third, in case of limited partnerships, the parties must, example, A. Sign and swear to a certificate which shall state, among others, the name of the partnership, adding the word limited and the character of the business. B. File for record the certificate in the office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirements will only make the partnership a general partnership. So we have obligations of the partners. First, where contribution is money or property. Second, where contribution is industry. Industrial partner. A partner who merely contributed industry or services to the common fund. Third, Obligation of the capitalist partner. Capitalist partner, a partner who contributed money and property to the common fund. Fourth, responsibility between partnership and partner. Fifth, sharing of profit and loss among partners. Sixth, property rights of a partner. Seventh, liability of individual partners to third person. And lastly, liability of the limited partner. Next is law on corporation. Corporation defined means a corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. So, right of succession means that a corporation has a capacity to exist regardless of the death, withdrawal, insolvency, or incapacity of the individual stockholders and regardless of the transfer of interest or shares of stock. So we have kinds of corporation, and these are stock corporation, non-stock corporation, corporation de jure, de facto corporation, public corporation, private corporation, eleemosynary corporation, domestic corporation, and lastly, foreign corporation. We have advantages of a corporate organization. First is strong separate juridical personality. Second, limited liability to investors. Third, free transferability of units of ownership. Fourth, centralized management through the board of directors. Fifth, professionalism. And lastly, easier to sell small amounts of stock to raise capital. So the disadvantages of a corporate organization is first, extensive government regulation, double taxation, and third, activities are limited by charter and various laws. Next, steps in creation and organization of a corporation. We have promotion and formal organization and commencement of the business operation. Contents of the articles of incorporation. First, the name of the corporation. Second, the specific purpose or purposes for which the corporation was incorporated. Third, the place where the principal office of the corporation is located, which must be within the Philippines. Fourth, the term for which the corporation is to exist. Fifth, the names, nationalities, and residences of the incorporators. So we have qualifications of incorporators. A natural person. B, not less than 5 but not more than 15 incorporators. C, of legal age. D, majority must be residents of the Philippines. A, must own at least 1 share of the capital stock of the corporation. 6. The names, nationalities, and residences of the incorporating board of directors until the first regular directors or trustees are duly elected and qualified. Then lastly, the authorized capital stock and the amount subscribed and paid by the stakeholders and incorporators. Paid up capital must not less than 5,000 pesos. And that's all on my report in Chapter 4, Law on Partnerships and Corporation. Once again, this is Jeneriel Cagas from BSHM 3B. Thank you and God bless.